Roger, this hearing that we're about to look at here took place starting at 10 a.m. on January 13th. Tell me why this hearing should not have been heard. When did you file your recusal?
Okay, I'm glad that you asked that question because it is an important question regarding Judge Breslow, Department 8 in the 2nd Judicial District Court in Washoe County, which is in Reno, Nevada. On December 20th, I filed a motion to disqualify Judge Breslow, and part of my exhibits, there were 5 exhibits that were affidavits. And my co-defendant, his name is Steward HANDTE, he signed an affidavit, a notarized affidavit explaining that Judge Breslow should be recused from hearing our case because we are co-defendants. Our cases have not been bifurcated. Judge Breslow did answer after 8 days. On December 28th, Judge Breslow put out a 1.5-page, very juvenile, in my opinion, answer to my quite extensive motion to disqualify Judge Breslow, in where the first 5 questions in his answer was pounding his chest and saying that what a wonderful judge he has always been. His last 5 answers to the 10 questions that he put on his answer is he acknowledged that there was some concern with a hearing in which he lost his cool and he threatened myself with contempt like he did today in the hearing, and he stormed off the bench, and he did not properly dismiss the hearing, and he left my co-defendant Steward HANDTE and his attorney Tom Pitaro sitting on the Zoom hearing, and he did not give them due process because they were there to express their concerns at this hearing as well. So that was one area of concern, and there was multiple in his behavior. So after his answer, the Chief Judge, Judge Scott Freeman of the 2nd Judicial District Court, issued an order referring the disqualifying affidavit to another department and another judge. So in my opinion, Judge Breslow lacked jurisdiction to proceed in this hearing today regarding Steward HANDTE. The state, Amos Steggy, the prosecutor, he filed a motion where he is attempting to place a gag order, a GPS monitor, and revoking Steward HANDTE's bail. All of those are a violation of law and case law. And I believe, and I tried to get the judge to allow me to make a comment, and he did not allow me, but I proceeded to make my comment anyway, where he lacks any jurisdiction because the case has been referred to a different judge. And he wants to believe that Steward HANDTE has a different case. But I do want to get on the record on this radio show that in every document that was filed, both my name and Steward HANDTE's name appear, and both of our case numbers. Our case numbers are the same, with the difference of the letter A and B at the end. We are co-defendants. We have not been bifurcated, and therefore every order, every motion, every issue has both case numbers and both defendants. So I hope that answers your question.
It does. And can you elaborate on how this all stemmed from you rescuing your mother from a Nevada rest home she was not happy in and taking her to a California residence, and then the state of Nevada kidnapped her back, after which she died in about 2 weeks after the state of Nevada kidnapped your mother back. So all this is about the Nevada state having a right to build the estate till it's bankrupt. Did I sum that up right?
You did. The case, the criminal case that I am facing, and my co-defendant, Steward HANDTE, we're being charged with kidnapping, conspiracy to commit kidnapping, and burglary. I don't understand where burglary comes into it. I don't understand where kidnapping comes into it. I don't understand where conspiracy comes into it. Myself, being a 30-year public servant of Nevada, my last 15 years were as a firefighter for the state, tasked with supervising inmates on all types of emergency response, from floods to fires to natural disasters. My co-defendant, Steward HANDTE, was also a 30-year public servant in law enforcement. When I talked to him about the neglect and abuse that my mother was receiving in a locked facility that she was placed in by a judge in the family court named Frances Doherty, she had been in that facility for 3 years. Even though I was retired at the time and willing to care for her, and did care for my mother for 3 years, because she did have some diagnosis of dementia and Alzheimer's, but she still maintained most of her rights. She still had the right to vote. She did not have the right to bear arms, but she had the right, in my opinion, to live with her son, because I was her power of attorney, named by her back in 1993, and that was never changed. I was also named as her successor trustee. So when I would go to visit my mother, Susan Hillygus, in this facility named Stone Valley in Reno, I always went there with witnesses. And we took photographs of black eyes, wet pants, unbathed, improperly dressed, ingrown toenails, and so on. She was hospitalized while at the facility for C. diff, which is a bacterial infection caused by human feces. The facility was given a bad rating by the state that investigated, and they retaliated against me, and they tried to isolate me from my mother. So when I did show up to ask my mother, the law enforcement person, Stu, said, we've got to do this by going and explaining to the Reno Police Department that your mother's being neglected and that they need to come there with you to witness that she wants to leave. Law enforcement refused to investigate the allegations, and they refused to get involved, claiming it was a civil matter. It was not a criminal matter. So I proceeded to the facility. We found my mother in the facility. It was witnessed, and I asked her if she wished to leave, and she said she did. And she said, thank you, get me out of here. The facility opened their doors. They bid us a good day, said, have a nice day. We walked out of there smiling, holding hands. And my mother, being raised in Southern California, wished to see her only living brother, I'm named after. His name is Roger Robbins, down in Long Beach, actually Bellflower. So I proceeded to take my mother to visit her brother in Southern California, where I was, after 1 week, I was tased while sleeping, taking great care of my mother. And I spent 2 weeks in the LA County Jail, and I was, I believe, illegally transferred back to Nevada without proper extradition orders from judges or governor's warrants or anything. They did not even use a warrant to arrest me in LA. They claimed that it was a 7-hour standoff. Nobody ever properly addressed to me that law enforcement was looking for me. I was sleeping in the wee hours of the morning when people came in to a door that was closed. It was not barricaded. It wasn't even locked. They tased me and took my mother to a hospital where she was evaluated and released to return to Reno. She did pass away. It wasn't 2 weeks. It was 2 months to the day. She was taken back to Reno on August 16th of 2019, and she passed on October 16th of 2019. I was not informed that my mother was placed on hospice. I was not even informed that she had passed. I attempted to have a pathology autopsy and a blood draw to see the drugs that she was given, and I was refused, and my mother was cremated, even though I was the person that my mother and father had put in place to determine her end of life arrangements. I hope that answers your question.
It does, and I thank you. This is just outrageous. I think to the average American, if this was to happen to their mother, I think they would be outraged, just incensed and outraged. So you can be kidnapped even from your own family, and the state of Nevada put in charge. And has the state of Nevada, I got two questions. Has the state of Nevada now assessed the value of your mother's estate and put liens against it for the bad care in the Nevada care home, and for the attorney's fees, and for extricating her from California against her will and putting her back in Nevada where she died? Have they filed fees? And secondly, you may not know the answer, but have you inquired to see if Friends of the Second District Court in Nevada own that care home in Nevada?
Okay, thank you for your question. I do want to backtrack a little bit and explain to you that in the process of rescuing my mother, aside from going to the Reno police, I had done quite a few other processes that you might call, by changing her address, by creating an address in California and changing her address through the post office. I also opened up a joint bank account in California, and I went to the Social Security Administration and had her Social Security removed or placed into that joint bank account in California. So when my mother and I left the facility, we proceeded to California, where I had changed her residency. So she was now, in my opinion, a resident of California. And yes, she was re-kidnapped back from California to Nevada to be placed into 2 additional facilities. So when they brought her back, she was placed into a facility and then later removed shortly after, within a couple weeks, it's my understanding, and removed to another facility. And as far as the finances go, my mother was being charged approximately $10,000 a month from the facility, from the guardian, from attorneys, and from all of the, I call them the cabal, that were involved in keeping her from her home and her son, who there was only allegations against me. I had never done anything wrong. I'm not a criminal. I've been, like I said, a public servant. And all I wanted to do was care for my mother. I never asked for money. I never threatened anybody. I've never been involved in domestic violence. And I believe that they accused me of being armed and dangerous, and that I've got some type of a mental disorder, which I clearly do not. And I can tell you I was not armed and dangerous. I've never threatened anybody. And all I wanted to do was care for my mother as best as I could for as many years as she had left on this earth. And I believe she would have had quite a few more years, and her life was cut short by the actions taken by the state of Nevada. I hope that answers your question.
That answers the first question. Second question, do you have any knowledge of any of the people who work for the DA or the state of Nevada, the court system, having ownership in the care home of Nevada? You gave the name of it. Do they have any ownership, or do their friends have any ownership? Do you have any knowledge of that?
So I do have a little bit of knowledge about the ownership of Stone Valley. And the reason that it's called Stone Valley is it's on Stone Valley Road in Northwest Reno. The original owner, I believe, is called JEA Associates. Jerry Irwin Associates is a foreign liability corporation out of Vancouver, Washington. Jerry Irwin sold his corporation to a new corporation called Sunshine Living, LLC, that's owned by an individual named Luis Serrano. And I believe his wife is named Sunshine, and they live in Irvine, California. They have employees, and I can tell you that my mother had a guardian ad litem. His name was Ryan Earl from Reno. It's my understanding that Tim Grafton, the administrator and director of Stone Valley, is the son-in-law of Tim Grafton. So there is a relation. It's my understanding there is a relation between my mother's guardian ad litem, who was responsible for getting her placed into that facility, and the director of that facility. But aside from that, I do not have any other information if the district attorney or the state of Nevada is involved in ownership of Sunshine Living.
Very good. Well, thank you for this interview, Roger. We'll see what happens next Thursday.
Very good. I appreciate you giving me this opportunity, and looking forward to talking to you soon.
Thank you.
Goodbye.
And now people will look at the Zoom video from the court that held today. This is William Wagner for On Second Thought, hoping this gives you second thoughts about whether you really have a pre-existing right to your own parents and your family members, or does the state own us people as chattel? It's a question we're thinking about. Here we go.
Okay, good morning, everyone. Let's get started. We are on the record in the case of State of Nevada versus Steward HANDTE, case number CR19-1535B. I am Judge Breslow, presiding from Washoe County, presiding judge in Department 8. We are proceeding remotely today on account of the global COVID-19 pandemic, as we have largely for the last 20 months. Or so. We are allowed to have hearings remotely, consistent with Nevada Supreme Court Rule 9 and various administrative orders of the court. Welcome, court reporter Ms. Ermston, and welcome Ms. DeGaynor. Starting with Mr. Steggy, prosecutor, if you would kindly identify yourself for the record, followed by defense counsel for Mr. HANDTE.
Good morning, Your Honor. Amos Steggy, representing the state of Nevada, appearing from Washoe County, Nevada.
Thank you. Defense counsel.
Your Honor, Attorney Tom Pitaro, on behalf of Steward HANDTE, attending remotely from Las Vegas. I do need to put on the record something I think even before we start, Your Honor, when you think it's appropriate to get through the introductions.
Sure. And do me one favor, Mr. Pitaro, if it's possible to adjust your camera, we're only seeing 2/3 of your face. There you go. That's better. Thank you. All right. And then the court, Mr. HANDTE, good morning. Would you turn on your microphone for a minute and just identify yourself for the record?
Steward HANDTE appearing as representative myself here at the James D. Hoff Idlewild Memorial, Police Officer Memorial, Idlewild Park.
All right, thank you.
Roger Hillygus, appearing as an interested party involving the case.
Thank you, Mr. Hillygus. Okay, Mr. Pitaro, Mr. HANDTE, do me a favor. Why don't you turn your volume off at this time so we don't get any feedback. Mr. Pitaro, go right ahead.
Yes, Your Honor. Last night, when I was looking at some emails to see if an item had come in, I came across an email that was sent out at 8:58 p.m. last night by Mr. Steward HANDTE to the Nevada Bar, to Kimberly at the Nevada Bar, stating in essence that I failed to file a writ of prohibition, that he wanted to stop this hearing, and that I exhibit a blatant ignorance of the law, and what is going on is an abomination of the system. As I said, I saw that last night, about 11 o'clock at night when I was looking at this. I spoke with Mr. HANDTE today to ask him, did he in fact send this email to the Bar Association? And he said, yes, he did. That puts me in a situation I do not believe I can continue to represent him, an individual who is accusing me of being ignorant, and then of course attempting to go forward with it. As the court is well aware, I did file a motion also for clarification concerning the hearing of whether we were really going forward or not, based upon the recusal motion and the prior order that it appeared that you were going to wait until the recusal motion was decided before you went forward. I don't know if it has or hasn't, given the way the filing is if it's Mr. Hillygus' stuff, sometimes it doesn't pop up in mine. But be that as it may. But as what happened last night after reading this thing, that there is obviously a conflict, and I asked that the court allow me to withdraw as attorney of record.
Thank you. A couple things. First of all, Ms. Armstrong, I want to make sure you heard all that, because again, with Mr. Pitaro, it's sometimes he slides underneath the bar and it's a little hard to see him while he's speaking, and it's not coming in quite as loudly as other people. So are you okay? Did you get everything he said?
I got everything he said. It would be helpful if he were up higher and like he is now currently.
Okay. All right.
And I'll interrupt if I don't.
Thank you so much. All right. I also noted, thank you. So to the substance of what you just said, Mr. Pitaro, I also heard Mr. HANDTE, when he introduced himself, indicate he was self-represented. So that's something we have to address. And third, I want to remind Mr. HANDTE and Mr. Hillygus that they're in court right now. And when we have Zoom hearings, when you're in court, you are to be inside, seated in front of a plain background. You know, I overlooked the fact that we had, I don't know what it's being called, a mojo chair or a mojo altar, because it really, I didn't dial into that. But, you know, going forward, when we have Zoom hearings, the court order is consistent with administrative orders: inside, seated, with a neutral background. You can have the United States flag as the court does. You can have a Nevada flag as a prosecutor does. You can do it from an office, your living room, wherever, but it has to be a neutral background. Outside, in front of a peace officer memorial, no matter how well intentioned that is, you're in court right now. We don't hold court out there. So I'll likely overlook that today, but going forward, I'll expect you to abide the court's order. All right, now let's get to the issue that Mr. Pitaro has raised, which is he believes he can't go forward ethically in light of concerns that have been expressed by his client. And then I have Mr. HANTTE identifying himself as a self-represented litigant. And so I'll give you my further thoughts on that in a minute, then I'll hear from Mr. Stege. But Mr. HANTTE, if you would go turn your camera back on, your volume, I mean, and answer this. Do you intend to seek to represent yourself in this matter or hire new counsel? Or what is your intention right now, sir?
Well, Your Honor, first of all, I believe this hearing is being held in violation of NRS 1.235, Section 5A and B. And secondly, I do intend to represent myself once I file substitution of counsel paperwork with the court. And I plan to do that either today or tomorrow, as soon as possible.
Okay, but by filing substitution of counsel, you're not going to actually substitute Mr. Pitaro. You want to substitute in yourself. Is that right?
Correct.
All right. Well, for the court to allow that to happen, I have to make certain findings after we have a hearing consistent with Nevada law, similar to the hearing I had with Mr. Hillygus. And after I made findings there that he understood the consequences, risks, and approaches, among other things. But
Then, Judge, I would respectfully request from the court that I be granted some period of time, as you did for Mr. Hillygus, to prepare for that Feretta hearing.
okay, and if that's where we're headed, I think that's a good idea. The question is, how does it impact what we're doing today? I mean, let's all get real here. The state has been pushing hard for a hearing on this, notwithstanding that the Hillygus case is stayed. And let me clarify to Mr. Pitaro and all participants on this call. When there was a motion to disqualify this court filed by Mr. Hillygus, by operation of law, this court can take no further action on his case. Because there were several overlapping issues, I declined to move forward further on some issues with respect to Mr. HANTTE's case, waiting to see what the result would be of the disqualification motion. This, however, is not one of the motions that I'm prepared to wait any longer. The state has indicated it has concerns with Mr. HANTTE's bail status and the terms and conditions of his pretrial release. And so that piece can go forward, notwithstanding that there's a stay in place by law on Mr. Hillygus's case. With respect to whether we go forward right now, in light of Mr. Pitaro's concerns and in light of what Mr. HANTTE expressed his intentions to be, I'm still giving that thought. My inclination is to have this hearing anyway, to indicate Mr. Pitaro remains counsel of record until the court allows him to withdraw, to not allow these recent developments to postpone this hearing and to move forward. But before that decision becomes final, I want to hear please from Mr. Stege and then back to Mr. Pitaro, please. Mr. Stege.
Thank you, Your Honor. I am hearing Mr. Pitaro saying that the substance of the email amounts to what would be a bar complaint. And so I take no position and I yield to Mr. Pitaro's superior knowledge in that area and that process. So as to whether Mr. Pitaro should be allowed to withdraw, I submit on that. Moving to the question of Mr. HANTTE's stated desire today, twice now, that he wishes to represent himself, I would suggest we proceed, if that is going to happen, immediately to that. And the reason is twofold. First, we know from an email sent to court staff that is in the pleadings that Mr. HANTTE has been contemplating this or had this in his mind, or in fact, perhaps has already told Mr. Pitaro something along the lines of that he wants to represent himself. So more time, I don't see how on the record we have that would be beneficial except to cause a delay in this hearing. I guess secondarily, going back even further to previous hearings, there were questions about HANTTE's, Mr. HANTTE and Mr. Pitaro continuing their relationship in this case. So I suggest the following, that Mr. Pitaro's motion is probably well taken, and that the time for a Ferretta canvass would be forthwith, either today or in the very short immediate future. I would not, given my concerns on the bail, I would not want them to be delayed by an unnecessary, in my view, continuance. Alternatively, if the court believes that a delay is necessary, I would ask for some relief, some sort of intermediate relief related to my motion in the form, and that based simply on the pleadings in the form of the GPS monitoring. I'm prepared to argue for the other things, but if we are going to continue it, I would ask for, as an intermediate sort of temporary remedy for my motion, that he be placed immediately on GPS monitoring until the Ferretta hearing and that issue is sorted out. So unless the court has any inquiry, I'm prepared to submit.
Thank you, Mr. Pitaro. What would you like the court to know that you haven't discussed already?
Your Honor, obviously, me being in or out of a case is determined by the court, not necessarily by me. I don't move to withdraw lightly. I've had a lot of difficult clients in my life, and you sort of muddle through, just as the court says that they have a duty to hear. Well, we have a duty to represent. I bring this to the court's attention because although, without getting into issues that Stewart and I have discussed over the course of the representation, filing a complaint with the bar is a very serious matter. It affects my reputation as an attorney. I'm very familiar with the bar proceedings. I do quite a few bar hearings representing attorneys in front of the panels. So that being said, that is the basis of the motion, of the request I made. Because as I say, I found that out about 11, 12 o'clock last night when I got out of bed to look for something, and lo and behold, there it was. And I confirmed that with Mr. HANTTE this morning, if in fact he did file this, and he said he did. All right, so that's where I stand on that, and then the court makes the decision. I have no problem with that. We did file responses to the state's motion, and they've been on file for a while. Obviously, I'm familiar with those, saying we wrote it, and I am prepared to argue bail if ordered by the court. I will not voluntarily do it. I will do it if the court tells me to do it, of course, and then I will argue the bail issue, which, quite truthfully, I don't think is a proper motion. But be that as it may, so I'm prepared to do that or whatever the court wishes. But no matter what we do today, going forward in this case, I'm assert that the filing of the case, call it an information. I don't know what an information is when you tell the buyer that your attorney's blatantly ignorant and won't do what you want him to do. There are reasons why I do things and not. As far as, and I do want to go back to the issue of the recusal. Now, I've only been involved, as I remember, in one recusal motion under this statute, which is identical to the federal statute because this happened in federal court in a 20 defendant case. In that case, that when the judge left, the determination of the recusal and who it applied to me, applied to the case, not to the individual defendant. And that's why I filed that motion for the clarification, is that if the recusal applies to the case, then it affects everybody. And so that was the reason I did that. And my only experience with it going back over 20 years was in federal court, where it did not operate as a severance. The judge was replaced by a judge from another circuit to come in and try that case. So that's my position on that. And that's why I filed that document to bring that to the attention of the court. I did not find case law that said one way or the other, as obviously many times we don't. It talks about when you do something. I will point out that I did not, under that statute, I did not file the certificate that would have been required of me if I had filed the motion. That is, if Mr. Handy filed a motion and was represented by counsel, then I would have been obligated to either file a certificate or not. I did not file a certificate. The reason I think it applies to the case is the manner in which Mr. Hillygus framed the motion. He spoke about affecting the defendants, and he had Mr. Handy, of course, in the caption. So that's my thinking on the recusal part under chapter 1, and that's why I made the request to discuss that before we went forward to see if we're going forward. Beyond that, I mean, I don't know if Stewart would want me to continue on to argue the bail motion. If the court orders me to, I'm prepared to argue it. I've got everything here ready to go. If not, if he doesn't want that and the court acquiesces in his desires, then I'd ask them to be removed as counsel, and then you do your further canvassing and go from there. So I leave that up to the court as to how they want to proceed.
All right, thank you. Mr. Hanty, if you could turn your microphone on for a minute. So did you file a bar complaint against your attorney, Mr. Pitaro?
No, I did not. I filed an informational report. There is an official form through the Nevada Bar Association that deals specifically with complaint, and that I did not utilize that form. I just filed an informational email to the executive director of the Nevada Bar Association. So the answer to that is no.
All right. So here's what I want to do. I want to move forward now with arguing this motion for a change of bail status. I want to set a FireFighter hearing for next week. The question is, Mr. Pitaro, you'll recall when Mr. Hillygus wanted to represent himself, I had his then lawyer present, and at the end of the canvass, once I was assured that Mr. Hillygus could represent himself, at that point his counsel was released. Those hearings I would do in person. So, we all know what's going on outside in the world right now, and you've already, expressed legitimate concerns on any travel or out of town, court appearances. But, if I set a FireFighter hearing, it would certainly be of assistance to the court if you were here. And so I'm going to, whatever comes of this hearing now, give some thought to how we accomplish that, hopefully next week sometime.
Let me just say, Your Honor, I think that can be done by way of me doing it by Zoom, because the question you're going to ask is going to be directed towards Mr. Hanty, not necessarily me. The decision that you would make, of course, would be whether you're going to grant two things. One, my withdrawal, and two, of whether he is going to be able to represent himself or have a standby counsel.
Well, that's mostly true. But then you lose some of the nuances in a two-dimensional hearing. The nuances of maybe Mr. Hanty wants to speak to you out of the court's presence, or maybe you want to go in the jury room during a break and discuss what the issues are. Or maybe, now, can we take a break from Zoom and you call each other? Yes. Can we get through it? Yes. It's just sometimes.
We have the ability to do the ones I've done before. We have the ability to do breakouts where
Okay, hold 1 second. Hold 1 second, because I believe Mr. HANTTE and Mr. Hillygus, their phone dropped. Ms. DeGainer, please reconnect them as soon as they join. All right, Mr. Hillygus, Mr. HANTTE.
Hold on. Okay. Judge, my phone died. I have Mr. Hillygus. I'm on Mr. Hilligus's phone now.
Okay. Do you have enough battery length? Because if we proceed with this hearing now, this could take a few minutes. So I want to make sure we don't lose you
Well,
again.
my phone does not, because the cold sapped the battery's not good in the phone to begin with. So we're using Mr. Hilligus's phone, and he does have enough battery strength.
All right, thank you. Then, Mr. Pitaro, please finish that thought, because Mr. Hillygus and Mr. HANTTE got cut off in the middle.
Yes, Your Honor, I believe it can be done by way of Zoom. Zoom has the ability to do breakouts, which in almost all the hearings I've had, we've had breakout sessions where you're able to communicate with a witness, a client, or off the record. So Zoom has that, and so I don't think any communication I have with him would be aided by going. I will say this: I take this damn thing seriously. We just lost another attorney yesterday. He's now on quarantine. 2 weeks ago, we had another attorney, and I don't, even though I've had all the shots and the boosters, I don't particularly feel like getting on a Southwest Airline plane with 150 people on it and run the risk, because I do think there is the alternative. And so I would strongly urge the court to allow me to do it by way of Zoom. If a problem arose and we had to do it, then obviously, then I will do what would have to be done. But the first instance, I would rather do it by Zoom rather than going up there. And as the court is where I pointed out, we have the same administrative order down here in Las Vegas as you folks have up there with the accommodation by Zoom, given what's happening. And at least according to the news accounts, the next 2-3 weeks may be the worst 2-3 weeks that we have in this, and then hopefully it tapers off in February.
All right, well stated. I understand where you're coming from, and that makes sense to the court. All right, so I want to explain this to Mr. HANTTE and of course, Mr. Hillygus. We're going to proceed with the argument on the state's motion with respect to the court's ability to hear that, notwithstanding the stay on Mr. Hillygus's case. Like Mr. Pitaro, this court's looked into the issue of whether the court should stay both cases pending resolution. And I'm not convinced there's authority that requires that. I told you that in my preliminary comments that I have essentially self-imposed a bit of a stay on the issues that are overlapping. But this one is unique. This request for a bail change and terms and conditions of release change is unique to Mr. HANTTE. And that's why the court finds no legal impediment to going forward this morning. With respect to the Ferretta canvas, to make sure Mr. HANTTE is able to make an informed and intelligent decision to represent himself, we'll set a hearing on that. And yes, I'll give Mr. HANTTE some time to prepare, but that hearing will likely occur next week. Yes, it can be by Zoom for the reasons Mr. Pitaro stated. But again, Mr. HANTTE and Mr. Hillygus, I'm going to require you to be inside and make sure that a neutral backdrop. All right.
Your Honor, may I be recognized and approached and appear before the court as an interested party?
Well, you have an opportunity to observe this hearing because of the case you have and your self-represented status. but this is not your motion, and the requested relief by the state does not apply to you. So at this point, I'm not going to hear from you, Mr. Hillygus, because this motion and the issues we're here to address does not directly impact your case. Your case has stayed. I'm hopeful
I would
that
object to this hearing moving forward.
well, Mr. Hillygus,
A writ
I
of
just said,
prohibition will be filed with the Supreme Court, and
Mr.
that your
Hillygus.
orders will be null and void.
Mr.
Your orders will
Hillygus,
be null and void. You have no jurisdiction in this matter. This is once again another reason this is a federal matter, that there are concerns that have been filed by Steward HANTTE in an affidavit. That affidavit has been filed with the court.
Mr.
Both
Hillygus,
cases
I'm only going to tell you this one more
appeared
time.
on
You
this.
need to, Mr. Hillygus, please stop talking. If you,
I just
if
want
you-
my objection on the record,
Mr. Hillygus,
that I
You-
object to you having jurisdiction to move forward in this matter. Thank you.
Right. Mr. Hillygus, the next time you do that, I'm going to hold you in contempt. We're going to have a hearing, and there may be repercussions and consequences that I don't want, and I know you don't want. You've expressed your views on these legal proceedings several times, and it's not necessary to do so again, particularly in a hearing that doesn't involve you. So I encourage you to abide the court. All right. Mr. Steggy, we're going to move forward with the hearing. You may proceed on what relief you are requesting, why you believe the court should follow your recommendation, and what authority supports it.
Thank you, Your Honor. The relief I request is GPS monitoring for Mr. HANTTE. What we have here is, as is often the case, a person is released from custody after arrest before, without any hearing, sort of on an amount set by a justice of the peace. In this case, that led to a subsequent hearing based on the allegations that of statements made by Mr. HANTTE in a gun store related to people in the case, named people in the case were going to pay. As a result of that hearing, Justice of the Peace Sullivan found that Mr. HANTTE, she amended his conditions, ordered that he have no possession of firearms. The law allows for, given the changed circumstances or the since that hearing of Mr. HANTTE's behavior, to guarantee, right, that the overall effective or point of bail is make sure a defendant appears and ensure he's not a danger to the community. Appearance is not an issue. In this case, it's not really in play. More in play is sort of the risk to the community from the defendant. Now, many of the bail factors touch on that, but it includes a defendant's mental status, reputation, etc. Now, I have laid out for the courts a series of incidents which are troubling in the state's mind. First, being the statements of Mr. HANTTE's wife or estranged wife that Mr. HANTTE does possess an additional firearm that was not turned over to a third party. Now, this highlights an issue that sort of affects the entirety of the court, which is our court, or this court, has an arm that sort of monitors or is charged with supervising, and I, the court has probably heard me make this argument before, but the supervising pretrial defendants. Now, that supervision is a bit of a misnomer, especially nowadays, being given COVID, et cetera, that the main tool they have is the number of check-ins that a defendant has to do. In COVID, and often before that, it was electronic check-ins. We're talking people getting online and checking in, or making phone calls to their supervising officer. That, I believe, is inadequate in this case. So the question of whether how the court can monitor a condition that is ordered is made difficult by the court's enforcement arm really being rather meager in some instances. And this is one of those. So the ability to check on the compliance relies simply on a defendant's word and Mr. HANTTE's word here. That's troubling. I think that's a pretty compelling evidence when the condition was added because of guns, and here we have a violation of or allegations of it. And I submit they are well-founded, sort of given the context of them. So that's the one. We also have this series of contacts by Mr. HANTTE with witnesses in the case. We have him going to the FBI office and being engaged in behavior or a confrontation with people at the FBI office looking for a person that was peripherally related or involved in this case. We have Mr. HANTTE going to the law office with no business there of the former prosecutor on this case. It's fair, I think, to call that a pattern of intimidation or attempted intimidation. He had no business there, had no business at the FBI office, but to confront them about issues related to this case. We have the social media postings as well added into this under this sort of, and it really gets to the defendant, Mr. HANTTE's mental condition. This conspiratorial thinking, this sort of veiled threats that I've highlighted here, this, you Pearl Harbor me, I'll Nagasaki you. That is language will probably be argued. It is free speech, but in this instance, and as related to, given the history that we know, it is troubling for the court in its consideration of public safety as well as the safety of witnesses and the people involved in the case. We have, and it's sort of some bleed over from another motion I filed, which is, statements. Well, let's talk about more social media postings. He is called in social media postings one of the witnesses, the victim in this case, her daughter, a murderer. This sort of slanderous statements also, and that sort of bleeds into that other motion on my gag motion. But I think that paints a picture of sort of a risk to the community and the people involved in this case, one that can be mitigated by the relief I've asked for. Now, if we were to revoke Mr. HANTTE's bail and increase the bail, that is one option. We do not know much about the defendant's financials. Yeah, his financial situation, although I think it is known he's now working as a delivery driver. Add that to the mix on public safety. So that I think is probably inadequate for what we're seeing. GPS monitoring, that is a tool that's sort of a high end.
So hold on one second. Mr. HANTTE, would you please get back in front of the camera? Thank you, sir. Go ahead, Mr. Siggy.
GPS monitoring is a high end tool available from the court. I think that provides a measure of monitoring and understanding of Mr. HANTTE's whereabouts as it relates to public safety.
DAS GPS monitoring is not an option, nor is any DAS supervision. I want to make sure we're all aware of the administrative order that came out when Chief Judge Freeman was presiding judge here in 2017, indicating that once a defendant is bound over, all supervision will be overseen by pretrial services, not by DAS.
Okay,
Now,
although,
there are other GPS providers and monitors, but the DAS option, it seemed like the state was asking that piece be embedded in any relief, and the court was inclined to grant the motion in part. That's really not an option as I see it.
okay, that's news to me, Your Honor. Not understanding that the distinction. If they had it in justice court, it may continue after bind over, but as a first instance, it cannot occur in district.
Well,
court.
let me even be more specific, because I don't even know if that contingency is available. Give me just a moment, please.
And Your Honor, Mr. Meredith, pretrial services is raising his hand. He may have a,
Well, you could, yeah, go ahead and bring him in, but I'm referring to Administrative Order 2017-13. I'm going to read from that. It says, when jurisdiction over a defendant is transferred from a limited jurisdiction court to district court, supervision over the defendant shall transfer to pretrial services if the defendant is not already supervised by pretrial services. And so I think that's clear. Mr. Meredith, welcome. Would you identify yourself for the record and tell me if you have any experience with DAS supervision after a defendant has been bound over?
Good morning, Your Honor. Cody Meredith with Pretrial Services. So you are correct regarding the administrative order. Regarding DAS, I do believe we can consider them as a vendor as well, a vendor for a GPS unit or a vendor for a drug test.
Oh, I see. But in supervision responsibility would remain with pretrial services, but at least from GPS monitoring, DAS is a vendor like any other independent provider. Is that fair?
Correct, Your Honor.
All right, thank you. All right, so Mr. Meredith, you can go dark. We'll call you back if we need you. Appreciate that. All right, Mr. Steggy, hope that clarifies it, but please continue.
Yeah, so I think that's the most immediate and I think fitting remedy for what we're seeing. When we get to that gag order, that may aid as well. I have characterized the social media postings as well as, the email to the court. All of that is sort of intimidating, confrontational, and conspiratorial. So as a secondary remedy, and I know this is one that we have used in this district, is a mental health evaluation for the defendant. We are seeing, and everyone is corrupt, according to him, from the investigators to the others involved in the case. He then, after the prelim through Judge Sullivan into that, and is now by his affidavit to in the co-defendant's case, added Your Honor to that. So I think there is a decent basis for a professional mental health evaluation, and that he comply with any further recommendations of that. I believe, so if we have GPS, that's what I want. Mental health, I want that. Now, what do we do about these allegations of possessing a gun? If he has a gun, he must turn it over. He must, as ordered by Judge Sullivan, a third party must be in possession of those. I do not believe, and I'd be interested to hear from Mr. Meredith if there's been any, if there was, since the filing of this motion, the information from Mr. HANTTE on that. If those are not adequate, Your Honor, then I would say we have no choice but to revoke his bail and to increase it, and to increase it enough where the risk to the public is sufficiently minimized, Your Honor.
Thank you. Mr. Bottaro, your thoughts, please.
Thank you, Your Honor. Let me just start.
Mr. Pataro, please speak up. Thank you.
Or can you adjust your camera?
I can try. I'm afraid it's going to fall. Last time I did it, it fell, but I can see if I look at that.
And in Your Honor, sorry to interrupt, if I could just direct you to 2 emails that I sent you before this hearing is over, if you could review those.
Okay.
Thank you.
That seemed to work.
That's better, Mr. Bottaro. Thank you.
Okay. Let me just start at the beginning with, in fact, the motion itself. As I pointed out in our points of authorities, the motion is not well-founded. It should not have been filed. It does not, quite truthfully, meet any requirements of subsequent conduct causing an increase in bail or conditions. And so that is our position, and we stated it quite clearly in there. The standard of bail, of course, goes back to, Valdez-Jimenez case, which quite truthfully everyone thinks was so revolutionary. All it did was restate the law in a more concise way that should have been followed over the years. But nevertheless, it does set forth a number of factors for bail, and included in that, of course, is the Valdez-Jimenez decision and subsequent decisions. It is the burden of the state to prove by clear and convincing evidence that these situations exist, which would initially the imposition of a condition, and then secondarily of adding a condition afterwards. So that's our position just up front. We don't think the motion is well-founded. We don't think it has any merit, as I will go through in a moment. The second thing is, in the motion, what most of the motion dealt with was conduct prior to Judge Sullivan setting the bail condition, i.e. the gun condition. And I want to address that because the state seems to have argued that Mr. HANTTE, by being charged with a crime, but not yet going through the preliminary hearing and being formally bound over, that there was some sort of violation. What they did is, or I think they did, they tried to rely on 18 United States Code 922, which is the federal gun law, which I do a bit of federal work, so I'm pretty familiar with the gun cases because they come up in almost every one of them. But there is no violation. There's no federal prohibition. It is only after a person is indicted, that is, after a grand jury finds probable cause to go forward with the case, that the prohibition comes into effect. Of course, in the federal system, you must be indicted, as the court is aware, constitutionally. In the state system, we have a dual way of doing it, and that is either indictment or by preliminary and affidavit. After the bind over, I think it's clear that 922 does apply. That you're not supposed to possess it afterwards under the federal law. There is no state law that prohibits it at all. So what we're talking about is interpretation of federal law. After this hearing, or during this hearing, we went through with witnesses, et cetera, and Judge Sullivan made a ruling. Obviously, I disagreed with the ruling, but nonetheless, that was, in fact, her ruling. We had a hearing and we had witnesses, and the state had an adequate opportunity to present its evidence to Judge Sullivan, as did I. And I want the court down to address this issue clearly, because it was addressed by the Nevada Supreme Court in the Cameron case. And I cited the Cameron case. And I would urge the court to, if it hasn't read it, to go back and read the Cameron case. Because basically what the Cameron case says is as follows, is that if its conditions of bail are set in justice court, and then the person is bound over into district court, when the district court accepts the bind over and those bail conditions, that's basically the end of the story. That issue has been litigated. You don't go back and re-litigate. In Cameron, that is what the Clark County District Attorney's Office attempted to do. And the Supreme Court said that it was improper what they were doing. And that the judge did not do any canvass that would have shed light, that would have been something that had been totally unknown at the time of that hearing that would warrant the district court to do it. In other words, when you accept the bail, the Supreme Court says that's the bail. Then if you're going to change it, you then have to go in and find subsequent conduct. So Cameron basically knocks out almost all of the motion. But I do want to address a couple points that the state raised that, once again, I think are incorrect. One, they seem to imply in there is that Mr. HANTTE could not possess a firearm because he was charged in justice court. That is not correct. A reading of 922 clearly shows that. And the state law on that deals with once an indictment comes down, and of course, correspondingly to an indictment is our information. So there was no prohibition against it. What is interesting is that what he was doing in that, he was doing what you were supposed to do, and that is to transfer a firearm. You have to go through licensed firearm dealers. I'm not a gun enthusiast at all, but I was given a decorative gun, I guess you would call it, by my brother-in-law in Massachusetts, and we had to go through licensed dealers to get it out here so that I could go even pick it up. And that's what Mr. HANTTE did. Now, and that was all dealt with in front of Judge Sullivan. So when you read Cameron, you will see quite clearly that relitigating that is really not an option. And I will tell the court also what I did is I went back and not just read the case, I then went in the Supreme Court website and then pulled up the—
Give me 1 second. Okay, I want to make sure that I have Mr. HANTTE and Mr. Hillygus. All right, they went off camera for a minute. Please continue, Mr. Pitaro.
Yeah, so I went back and then I pulled the transcripts of what Judge Eric Johnson did during this canvass that we went through that the court found was insufficient. And I will say that Judge Johnson went through a lot of things, but once again, there never was that there was something that had happened that no one knew about that was so profound that it would have changed Judge Sullivan or that judge's ruling. And that's the basis of Cameron. And Cameron went up and I think writ of prohibition, and the Supreme Court intervened and sent the matter back, saying the judge acted improperly in trying to increase the bail. So that clearly takes care of most of it. I mean, the case law is totally against them with Valdez Jimenez, as well as the Cameron case. As Cameron versus the Judicial District, it's 135 Nevada 214. I'll just put the site in there. Now, let me go then to the issues that have happened subsequent to it that Mr. Stagey has spoken about. First, let's talk about this estranged wife. I don't think they're divorced yet, but that she says that she found a part of a gun, that is a gun without a clip, which my understanding would make it inoperable, but that really doesn't matter. But because what she said was, well, how long was it there? Well, she said it could have been there during the term of our marriage. That's 9 years. So what we're talking about is she's saying that there's some weapon in there that may have been there for 9 years. The next thing happens, what did she do with the weapon? Well, first, did she call the district attorney's office or the Reno police department or sheriff's office or anyone else? She was living with them. She knew what the conditions of the bail were, because I'd asked her to remove her weapons also, so that we didn't have the cross-pollination of her saying this is my gun and someone saying it was Mr. Hante's gun, etc. And we don't have the gun. That is clear and convincing evidence, is not double hearsay. We don't even know if this gun exists, quite truthfully. And I seriously doubt if it does. And one of the reasons I seriously doubt it does, because she was very specific, it was, I believe, a Kimber. Now, when Mr. Hante filled out and turned in the guns as he did properly at the request of Judge Sullivan, and we submitted the list to the pretrial officer, in there, of course, he listed that he had turned over a Kimber gun. So whether she is mistaken or whatever the reason is, I don't know. But no court, I believe, can find clear and convincing evidence that he has violated a condition by having a weapon, by having a wife in the middle of a divorce situation saying, I found a gun that might have been here for 9 years and I left it there. I didn't call anyone to come get it. I didn't give it to anyone. I didn't show anyone. I didn't take any pictures of it. It's gone. I don't know where it is. There we are. Therefore, we now find that Mr. Hante must have violated it. We refute that. He did not violate it. He didn't have whatever weapon that she was talking about wasn't there. He turned all his weapons over properly to the pretrial officer. Now, concerning the turning of the weapons over, the court had just received a few days ago, week or whatever, a report from the pretrial officer who told the court in the filing, I don't have it in front of me, Judge, but I'm sure you've seen it. And what she says is that he's been total compliance. He makes his check-in dates. He does that. She even lists the guns, that he did the guns. In other words, he's been total compliance with the supervision that is out there. Now, to argue that that is somehow a knock against him because he did everything right, I think turns logic on its head. They say, well, there's no supervision, he can run rampant. Well, he can't. We have an officer out there who has been monitoring this for months and says he's doing everything he can. Quite truthfully, you've been on the bench for a while. I've been an attorney for a while. Most of the time, we don't find people that does everything that they're supposed to do. There's always some little thing, minor or not. But Mr. Hante did everything he was supposed to do. We have that in writing. We have that from the officer of the court, the person who was appointed by the court, if you will, to do this monitoring. So that's where we're at on the gun. Now, the telephone call, I think, is interesting because it starts out, once again, this isn't a divorce matter. I don't do divorces anymore. And the reason I don't is it's just so ugly that the things that get said back and forth. I don't think anyone in divorce action is relatively credible, let alone a hearsay statement to make it clear and convincing. But in the report that was supplied by the district attorney's office, it is in there that the officer specifically states, I don't think there's that this the telephone calls, that there was any violation of the law. He did not commit any offense by what he did. And I'm sure the court has seen that in there where the officer said that, and that is, he didn't do anything wrong.
No, I did read, I have read all the materials provided.
Good, thank you. So the court is aware of that. So I think that answers the question of the wife and father-in-law and that dispute. There is no evidence to suggest that he has it. We have no tangible evidence. We have nothing at all, except that we know that a Kimber gun was listed on the sheet that Mr. Hante turned in months and months ago. So I think that should be enough dealing with the ex-wife and father-in-law. Now, what I want to do then is go to the attorney's office. One, Mr. Hante was not refrained from contacting us going any place under the order of Judge Sullivan. And he went to the attorney's office. He wished to speak to the attorney. He did not speak to the attorney, was able to speak to the attorney, and he left. And that's the first and the last time that this sort of contact was made.
You have to, let me stop you there, Mr. Pitaro.
Yes.
You have to concede, do you not, that that's a little bit unusual? That a defendant in an active criminal prosecution would search out the original prosecutor. I really haven't seen that before. Have you?
Well, I can give you what I think is the answer and why. This case has many twists and turns that are in fact unusual. One of the issues involved in this, from Mr. HANTTE's viewpoint, was the manner in which the criminal complaint was filed and the manner in which he was arrested. His arrest was not, let's go out and come on in, Stu, we got something. There had been conversations with the police, whatever. This was really a massive sort of thing of going out, and a total overplay by the police in the manner in which they arrested Mr. HANTTE. And it disturbed him that as a 30-year veteran of law enforcement, that he'd be taken out and be taken to the ground on a case of this nature when he had been in communication with the detectives, et cetera, and could not understand why this arrest would be happening on this way. And what he was attempting to do was see if he could get an answer from the person who was initially in there. Now, he was not a witness in our case, but he went there and I don't want to use it in terms of he had a right to be there, but he did have a right to be there. There was no prohibition. But when he said, what did he do? He wanted to speak to the person. Ms. Perez, I think it is, described him as non-aggressive. He was basically passive and then never got to speak to the attorney, and he left. He's never been back. He's never gone beyond that. Now, obviously, without getting into attorney-client stuff, him and I have discussed the matter of the arrest and these sort of things. And if he wanted to go out and check it out, there was nothing prohibiting him from doing that. I mean, common sense, I think, might have had a better play than that, but it wasn't criminal, nor did he do any act that in fact was criminal or harmful to anyone, nor did he make any threats to him. Non-aggressive there, went out, left, and that was the end of the story. Obviously, nothing happened, and so clear and convincing evidence of nothing happening is not clear and convincing evidence that the court has to go in and modify conditions of a release based upon it. The FBI office, the same sort of situation where you have the FBI involved. Now, what the court is probably not aware of, well, I don't know, you may not be aware that within this case, there are major concerns by Mr. HANTTE and Mr. Hillygus. The manner in which this case came down, the involvement of the police department, the FBI, and other agencies that led to the arrest of Mr. Hillygus in California, where I think, they described it as some sort of a SWAT type operation, when the only evidence that we have of it is that Mr. Hillygus was asleep on the couch. So when one wants to look at what Mr. HANTTE, Mr. Hillygus can speak for himself in his own case, but what we're seeing things that are unusual by law enforcement of what they did. Now, the state says, well, that shows paranoia. Well, even paranoids have enemies. And what we are finding in this case, and we have found, there's a lot of irregularities that in fact happened in this case. The FBI agent, he went out there, he was told, you're not, civilians aren't allowed in this area. He left. That was it. He didn't threaten anyone. He didn't do anything. He only wanted to talk to the individual. There's no prohibition against it. Ill-advised, probably. I like to have attorneys do these sort of things and not clients. But nevertheless, nothing happened. Nothing happened. And you can't buy clear and convincing evidence that because nothing happened, that somehow elevates his risk as a danger to the community. So once again, we have the same sort of situation. He left, and that was it. He was requested to leave. He did, and he left without incident. Likewise, any other communications that we were dealing with people, those are the three main ones, was the father-in-law, wife, the attorney, the former assistant district attorney, who apparently was initially in the complaint before Mr. Stagey got involved, as well as then the FBI agent who was involved and had involvement in it. Mr. Handy wanted some information. He didn't get it. He was asked to leave. He left. Exactly what a law-abiding person would do. If you're asked to leave, you leave. And he did that. Now, where we get even more troubling in this motion, and as the concern, is the ability of individuals to address their government. That's a constitutional right. And of course, it's almost, as soon as you say you have a constitutional right to do something, everyone says, well, that's meaningless. Well, it isn't. Mr. Handy, one, went to a county commission meeting. He sat there. We've seen the tape. I'm sure the court has seen the tape if you've reviewed it. He sat there until it was his turn to speak. He got up and spoke. He stated his feelings towards a lot of people, including the sheriff's, police, and the district attorney's office. There's no doubt he doesn't like them, and he's not shy in saying he doesn't like them. And the reason, as he puts it, is he thinks that they have systematically gone out to harass him and violate his rights. And quite truthfully, Judge, there's a lot of weird things happen in this case, and I'll get to the most important one, I think, in a moment. But he has a right to do that. It would be, I couldn't conceive of someone finding that it is clear and convincing evidence that the person is a danger to the community because he took his 3 or 5 minutes, whatever the county commission allows you to do, to make it. And what he ended up making is, of course, a freedom of information request, which was ignored, which of course played right into his feelings that mischief thou art afoot. But that's all he did with the county commission meeting. He did it. He sat down. When he was done, he left. Once again, he has a right to do that, and to even argue that that is somehow a violation of a bail situation or increases danger to the community is something I just can't get my head around that. Then we talked about the social media. Let me say this, and I'm sure the court has already got who knows exactly what it is. Mr. Handy has political beliefs that are held by a large number of people in this state and in this country. And that belief is that they don't think that fundamentally the government is working for them. The government is working against them. And Mr. Handy is honest enough to say it. Whether you agree with it or not, you agree with his positions or not, is irrelevant. That it is that he has the right to those opinions, and he has the right to express those opinions. And unless he has done something to harm somebody, then his speech is there. These are not fighting words that we have under the constitutional, the Supreme Court definition of a restriction on free speech by uttering fighting words. These were words that he put out, and in the county commission, totally proper. They probably didn't like having to listen to him ask these things, but nevertheless, he has the right. The social media is now, in this day and age, I'm a dinosaur on it, but social media is how people communicate. They don't write letters anymore. Yes, we don't even do too many emails anymore. It's done through social media. And his social, okay, I saw them went off camera from
Yeah.
his social media comments are in fact held by a large minority of people. And that is fundamentally the government doesn't work for them and government is against them. Now, obviously, you as a judge probably get offended by that because you are, from your viewpoint, out there trying to enforce it or interpret the law. Other people look at judges and look at them in a different light. The police, we all have the idea that the police are out there helping us. You know, we all have the story your mother told you, if you're ever in trouble, go to the policeman. Now, we had Mr. Cronin down the street. He was the captain in the police department. Anything happened, Mr. Cronin took care of it. Those days are long gone. There are many situations with the manner in which the law enforcement handles things that are subject to criticism. It's been all over the last 2 years. We've seen more of it than any of us, I think, ever thought we'd see or ever hope to see again on it. But these are real concerns that people have. And I want to jump now back to what happens in this case. Fundamentally, this case starts out, Your Honor, and I think we pointed out in the writ, but I think it's relevant to this. This case starts out that the lead detective.
I wonder if we could stick to the pleadings.
Well, yeah, I
It's
want to
like
make
a
sure
40-minute argument. I mean,
Yeah.
come on.
I want to make sure I know where you're going, Mr. Patara, because while some background is useful to show to set the parameters of people's behavior, response, impressions, really the question before the court is there a reason to change the current custody status? Is there good cause? Is there good cause? Is there clear and convincing evidence constituting good cause?
That's correct. And the reason I was mentioning the detective was because the issue was what was it that Mr. HANTTE was trying to find out? We did not know until that detective could understand that for 2.5 years, she was operating on erroneous assumption. And the police reports, interviews are replete with that. To me, that was shocking. And to Mr. HANTTE, I think it solidified his position that government was working against him and not for him. And I think that's why he is trying to find answers on it. When we're done with this, there really is nothing there. Cameron has answered the first half of it. And the fact that he went out and wanted to speak to someone and didn't, went out and wanted to speak to someone and was told that he had to leave and he left, that he exercised his right to state his grievances to government by going in front of the county commission. He did that following all the rules and regulations they did. We've all seen the tape and what he's asked for. And the social media, he's dealing with people, I believe, who have like thoughts that he has. This man, quite truthfully, during this whole period of time, has done nothing wrong. I don't think he's got a speeding ticket. He's done nothing wrong. He's done nothing that would allow a change in conditions. I mean, clear and convincing evidence is a substantial burden for the state to overcome on these sort of things. And what we end up with are what I think are suggestions to the court that just don't make sense to me in terms of where we're going. The court has dealt with the GPS situation, the house arrest with the monitoring. That is a major restriction on the ability of a person to freely move in the community. You now need the permission of someone before you can do anything, and you have to get their permission for. There is nothing that he has done that would warrant putting a bracelet on him. Quite truthfully, if the court thinks that, well, gee, that is strange, he saw the attorney, then the court could just say, okay, Mr. HANTTE, I don't want you just talking with witnesses. Do that through your attorney or through your investigators. That's done all the time. That to me is sort of like a constant giving, but that's where we're at. But then when the shift comes, where the shift comes is this mental health evaluation. Basically, what that is saying if you believe in Mr. HANTTE's political philosophy, which quite truthfully, as I say, a large minority of people believe, that you must be mentally ill. And therefore, we're going to treat you as a mentally ill person by having you evaluated. And then somehow, whatever that evaluation is or isn't, we want to place conditions upon you based upon your thoughts, based upon what you think and what you believe. That one's frightening to me. That one is really a frightening situation. We've all been involved. I've been involved where I filed the affidavit that I thought a client was incompetent to stand trial. And we went through and had the evaluations and the hearings, fingers dusty. We have those things, and then decisions are made by the court. But even in those situations, the decision is either you're competent or not. The judge doesn't then place conditions upon you because of perceived mental illness. And so that one really troubles me, Judge, that we would try to take a step of evaluating a person based upon what would in this case be his political beliefs, because his actions have been non-confrontational. Any situation he's had in this has been non-confrontational. He's been described in situations as non-aggressive, not committing a crime, and going forward there. So I want to end where I started. I don't think the motion is well-founded. I think Jimenez answers the question initially, as well as the question of whether one can modify the bail. The Cameron case is quite truthfully a very, very forceful decision by Justice Hardesty on it. Quite truthfully, if you will, reprimanding a district judge in the manner in which he raised bail and then improperly did it improperly. Especially the judge we're talking about is one of the most respected judges down there, Judge Johnson, who has an exemplary career. I've dealt with him for 30 years as a prosecutor in the states, in the federal system. So we have these cases answered, or these situations answered, one by the case law, and two, we have it answered by, in fact, the facts. If he went out there and told the attorney, I'm going to kill you, that's different. He never even spoke to the attorney. The issue, the FBI, he really didn't speak to anyone. You're not supposed to be here, you have to leave, and he did. And those were the ends of the story. When once again, the gun, I mean, I know how you can put a stock in a hearsay statement that I don't have the thing, and this is what it is. It might have been there 9 years ago, but you know, he really did nothing wrong.
I'm sorry, I heard Mr. Pitaro saying he was going to end.
I'm sorry, and he did nothing wrong. That is, when you look at the reports that the court has read there, he's not committed any violations of any law. He's not violated any conditions of the terms of release. He's made all his appearances for the period of time he's there. He has a record the court now has of all his turn-in time-ins from the people who do supervise him. Their thing is he did everything right. I understand. I understand the nature of this case when you have people who have beliefs that may disagree with other people's belief. And no court, and I appreciate, no court likes to be criticized, especially when it deals with their integrity. I understand that. No attorney likes to be criticized and we go they're blatantly ignorant. No one likes that. But those aren't the issues. The issues is, did he do something that warrants it? And the answer is no. And the state has presented no evidence to suggest that he has done anything but follow the terms and conditions that he has. He is informed he does not know what this gun is. He doesn't have it. If he had it.
I object to Mr. Pitaro testifying. If Mr. Hillygus, if Mr. HANTTE wants to make the statement about the gun, he can.
Well, I'm leaving it just that there is no gun. All we have is a hearsay statement of something that might have been there for 9 years.
Which
So
serves
I'm
superior to your statement.
at this point, what I have is Mr. Pitaro telling the court what his client has advised him, and I'll understand it as such. It's a different layer of hearsay than a statement made to a police officer in a report. But I wasn't sure, Mr. Pitaro, if you were going to ask Mr. HANTTE to speak to the gun or not. You're certainly welcome to, but you don't have to. But I hear you loud and clear. But let me say this, because one of the things that I've been thinking as you made argument, and very, very strong argument, just a reminder to Mr. HANTTE what an effective fine attorney he has right now. And of course, we'll have a Feretta hearing if he decides to represent himself. But I'm appreciative of the thoroughness of your argument and the thoughtfulness and intellect that's embedded. But let me just say this, Mr. Pitaro, and if you want to respond, because while, we have to remember there's a difference between the facts and the truth, right? It's a fact that nothing happened at the FBI office. There's a fact that nothing happened at Mr. Teague's office. But the truth is that Mr. Stagey is going to argue, Judge, the mere fact that he went over there, we can put aside that nothing happened because the people weren't available or he was asked to leave. But the mere fact he went over there is indicative of somebody that's trying to intimidate or trying to impact or affect how the course of this process of adjudication will occur. And it signifies somebody that might be trying to intimidate. Now, that's what I'm going to hear Mr. Stagey say. So wait, just a minute, just a minute, sir. So Ms. Pitaro, why do you disagree?
I disagree because this extrapolation does not hold water. It's contrary to what happened. The fact is what he did, and the truth is what he did. They are the same. We know that he went to the attorney's office. We know that he asked to speak to the attorney. We know he did not speak to the attorney, and we know he left. And we know that he was described as non-aggressive. With the FBI agent, he went to the FBI office. If one wants to speak to an FBI agent, I think it's reasonable to go to the FBI office. You've probably been to the facilities, the FBI office, like down here, you step one way, you're not supposed to, you have to go another way. He was told that he wasn't allowed, civilians weren't allowed there. He did not curse, demand, whatever, he left. And so to extrapolate that into some sort of threat, there was no threat. And I think that's, once again, the disturbing thing of trying to get into his mind that he somehow meant this to intimidate someone. If he wanted to intimidate the attorney, he could have intimidated the attorney. He could have stayed there. He could have caused a scene. He could have yelled. He could have done a number of things. He did none of those. If he was threatening the FBI agent, seems far-fetched, but if he would have said, I'm threatening you, you're doing this and that, etc. None of that happened. So
Okay.
I can't find the extrapolation of nothing becoming something in this thing. I will agree with the court if the court has this feeling. Clients shouldn't do this sort of stuff. That's why you have attorneys.
I don't know what that was.
I mean, and we understand that.
Let me ask you this, Ms. Pitaro. Your client's trying to get the court's attention. Would you like to have him address the court on issues related to the gun or any questions you want to pose to him? If we do, for purposes of this hearing, I am going to put him under oath because I want to make sure he's testifying truthfully. But right now, I understand where you're coming from. And so I'll leave it to you to make that decision, Mr. Pitaro.
Well, if Mr. HANTTE wants to do it, I mean, especially in the unique circumstances we're at now, I'm not sure that me prohibiting him from saying something to that. If he wishes to address the gun issue, he can. If he can nod his head, if that's what he wishes to do, then then I think he can.
But what we'll do then, Mr. HANTE, if you want to address the court, it has to be through question and answer, where your attorney asks you questions, you'll be placed under oath. It may be helpful to the court and for purpose of this hearing. It may not be helpful to the court, but if you'd like to do so, it sounds like he does. So Mr. Pitaro, at this point, Mr. HANTE, if you would please turn on your audio. Right now it's on mute. And Ms. DeGainer, please administer the oath of witness to Mr. HANTE.
You solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you, Mr. Pitaro, you may proceed.
Yeah, Mr. HANTE, under the unique circumstances that we both find ourselves in here, let me just say this for the record, is that normally I would not have a client testify given the nature of the argument and the facts. But due to the fact that you are seeking to represent yourself, I'm assuming you're going to disregard that advice and you want to address the court. Is that correct?
Yes, sir.
Okay. Do you want to address the court concerning the allegation of the Kimber gun hidden behind the bedstead for 9 years?
I would like to address the court on each specific issue that's been brought forth in these allegations against me by the district attorney's office, correct?
Let's go to the gun. Let's go to the allegations by your wife. Did you disobey Judge Sullivan's order by having a Kimber pistol in your house?
I did not. Those guns were provided to a person by the name of Mr. Harry Swift. They've been in his possession ever since I turned them over. He's willing to provide a sworn statement to that effect. So whatever information Mr. Steggy's providing to the court today is not evidence, it's hearsay. And that's ruled under United States Supreme Court, Frinzi versus Pagliaro. Any information obtained through my wife, a strange wife, is a violation of NRS 49.295 under spousal privilege. So therefore, Mr. Steggy in concert with, excuse me, I'm not finished. Mr. Steggy in concert with Detective Jenkins and my wife have violated NRS 49.295 spousal privilege. The gun has been in Mr. Swift's possession ever since it was turned over to him.
All right, so Mr. HANTE, thank you. At this point, just answer the question asked. If we have additional questions for you, we'll ask you. I don't want you going off on legal issues that right now I'm not asking you to comment on. Mr. Pitaro.
Do you wish to address going to the former Assistant District Attorney's office?
I didn't go to Mr. Pitaro. Yeah, I did not go to the District Attorney's office. I went to a law office in South Reno just to ask if Mr. League was working there. That's it. There was a mere question asked. If that's a violation of law, I sure like to see it.
Well, did you make any threats to him or his staff?
I did not.
And did you get to speak to the attorney?
Nope.
And then what did you do after you were unable to speak to him?
I got into my vehicle, left, and went home.
Have you ever gone back?
No, sir.
Okay. Let's deal with the FBI. Do you wish to address that issue?
I do.
All right. Did you go to the FBI office on the date that is mentioned in the motion?
I did, and I like to say that I did not go into the office. There is a voice call box in the outside in the public parking lot. That's where I made contact eventually with Special Agent Chris Taylor, who summarily dismissed me after I wasn't even able to finish asking a question about who I would talk to about reporting a RICO violation through a DOJ representative. May I expound a little bit more on that?
Well, no, that answers the question right now, Mr. Pitaro. Let's move on to the other issue with respect to the text messages sent to his estranged spouse. Please.
I'm not sure what text messages we're referring to, Your Honor.
I didn't send any.
Oh, beg your pardon. Then phone call with your father-in-law. Isn't that an issue that the state has raised that they argue appeared somewhat threatening?
It was a series of text messages, Your Honor, and it wasn't threatening. I was asking where my wife was since she abandoned the marriage and took everything out of the house, including my animals. And that's when I was at work. So she left the marriage in a way of deception. I would say anything that she said from that point forward is subject to credibility issues on her part.
Okay.
And it's hearsay evidence.
Okay, Mr. Pitaro.
You made no threats against your wife or her father, is that correct?
Correct.
Okay, and you read the police report that was made and submitted by Mr. Stagey in support of his motion?
Correct, in violation of 49.295, I have.
Yeah, let's leave that. We all know your position in that. And the detective in writing that report said there was no violation of the law in your communication with him. You remember seeing that?
I remember seeing that, yes, sir.
Okay. Has that been the extent of it? Well, let me ask you this. You are in a divorce situation. You and your wife are in court.
Actually, I have not filed for divorce yet, so technically right now she is just my estranged wife. I have sought legal counsel in terms of that aspect. I've retained legal counsel, but there's been no official filing of any paperwork. So at this point, Mr. Pitaro, we are just estranged at this point. We are still married at this point in time.
And
Today.
she has not filed action against you.
That is correct.
Okay. Now, we've dealt with that, the attorney's office, the FBI office. What I do want to do is, you went to the county commission meeting.
I did.
And why did you go to the county commission meeting?
To voice my concerns about the malicious prosecution of me by the district attorney's office, and specific Mr. Stagey, in acting in concert on his immediate supervisor, District Attorney Christopher Hicks.
You made that statement to them?
So many words, yes, it's on video, so if they want to use
video.
specifics.
And let me just ask this, you followed the rules that it was set by the county commission of citizens addressing the commission at the public forum portion?
I did, given my 3 minutes, I took almost 3 minutes.
Okay, and then did you leave?
I did.
Did you utter any threats against anyone during that?
No, sir.
During that meeting? Okay.
No,
Now,
sir.
The last one, of course, is, if I believe it's the last one, is the court was concerned about was some of the social media comments that you made. What media format were you using?
First of all, it's my Instagram account, and that's a private account. So I would find out why Mr. Stagey's been allowed to access my private Instagram account and through what sources. It's protected speech under United States Constitution, First Amendment. I did not threaten anybody. There was no threats that I would say I'm going to hurt you or kill you in my social media accounts. I made insinuations and allegations to the point of these people are maliciously prosecuting me. And, it's intimidation tactics by them. It's relentless harassment of me and retaliation. I believe that's protected under federal whistleblower laws, which I'm going to seek here in the upcoming days.
All right, but the point I'm getting to that within your social media comments, which went over a few day periods of time, you did not threaten harm to anyone, did you?
No, and again, I would find out why my private account's been accessed or hacked, and I did not threaten anybody or make any statements to hurt or kill anybody. I've never been a threat or danger to this community. I've lived in Reno, Nevada for over 45 years, which includes a 30-year career in law enforcement, unblemished. And there's been some situations that have been brought forth by Mr. Stagey through his employer that I have grave concerns about.
All right,
Ms. Pitaro,
I don't want to get into Mr. Stagey. I want to end this on that way. Mr. Stagey referenced a comment in one of the social media about Pearl Harbor and what was it, Nagasaki?
I can address that. I kind of use that as an analogy. That was said by Ted Nugent in regards to the pandemic, and I thought it was kind of comical where he goes, "If you Pearl Harbor me, I'll Nagasaki you." It's just basically tit for tat, and that was taken totally out of context by Mr. Stagey.
Okay, and that was a comment that you were actually quoting Ted Nugent, the
Singer.
rock and roll singer.
Correct. Yes.
Okay. Did you mean that as a threat to anyone?
No, sir.
Did you address anyone personally? Those comments addressed personally to anybody?
No, I thought it was kind of a comment in regards to what actually happened on Pearl Harbor Day. Yes, I thought it was kind of a decent analogy, but I never threatened or hurt anybody.
I believe I've gone through all of them, unless the court, there was one the court wished me to see inquire if he wanted to discuss.
I don't have any additional issues. I wanted to hear from Mr. HANTTE. Mr. HANTTE, thank you very much. I may let Mr. Steggy ask some questions here in a moment, but we'll see where that goes. Mr. Pitaro, unless there's a final thought, I'm going to turn to Mr. Steggy to respond to the arguments you've made. Mr. Pitaro.
That's fine, Your Honor, I'm done.
Thank you very much, Mr. Steggy. And by the way, if court staff or reporter needs a comfort break, we're due for one anyway in about 15 minutes. So, but if you need one sooner, please get my attention. All right, Mr. Steggy.
Thank you. Mr. HANTTE, did you say you had an unblemished career as a law enforcement officer?
That's correct. I retired in good standing from the Nevada Highway Patrol and I have a retired ID card to prove that.
Okay, you stated your plan to file a whistleblower complaint, correct?
That is one of my options and I'm going to look at that rather heavily, yes.
Well, didn't you just say you're going to file a whistleblower complaint?
I will say within 90%, so I guess that's a good probability, correct?
So yes, you're going to file a whistleblower complaint.
Well, he's answered the question, Mr. Steggy.
Okay.
You can move on.
Okay. It's true you've filed whistleblower complaints before that were unsuccessful, right?
Depending on how you view it.
Well, summary judgment, that's pretty.
I'm sorry, I would object to the question. I don't think it's relevant to the issue before the court, whether
Relevant to his bias, the man's bias, his honesty, veracity.
Amos,
I'm going to move beyond it very shortly, Mr. Pitaro, but I'm not negotiating with you.
Hold on. One person speaks at a time. There's an objection that's not relevant to this hearing. Is that right, Ms. Pitaro?
and he said he's going to move on. So that's that.
All right,
it's
please move.
I'll move on very shortly when I get my answers, my response to Mr. Pitaro.
Well, the question,
It goes to
Mr.
veracity. It goes directly to veracity.
I'll allow limited question, objections overruled. A few more questions on this line, Mr. Steggy, and then please move on. Mr. HANTTE, the question was, did you have summary judgment entered against you on one or more whistleblower cases in the past?
One.
Thank you. Mr. Steggy, next question, please.
Thank you. You, sir, on the subject of your social media post, you said that, in fact, there were many insinuations, correct?
That's a broad-based question. Please specify.
You just testified in your direct examination that your social media posts had many insinuations related to threats. Isn't that true?
Fair statement.
Okay. So what is the insinuation related to the Nagasaki comment?
Basically, tit for tat. Use an analogy. If you're gonna come after me, I'm going to stand my ground and forthright come back after you with allegations of violations of law and Nevada administrative codes, which you have committed.
Okay, and so that was not an insinuation about this prosecution and the criminal case against you.
Directly relates to this prosecution criminal case against me, Mr. Steggy, and I think you know that.
To which you drew the analogy of dropping a nuclear bomb on the Japanese.
Your analogy is incorrect. My analogy was just of tit for tat, and I use as a comical relief of Hiroshima or Pearl Harbor, Nagasaki. I only use that as an analogy. I didn't say I was going to drop a bomb or threaten or harm or kill anybody.
What portion of that is comical? The Pearl Harbor or Nagasaki, sir?
Your Honor, could we take a quick break? I've got to.
I'm almost done, Mr. Pitaro. I'm very close to finishing.
Let's go about 5 more minutes, and we're going to take a recess, right, Mr. Pitaro?
I'm supposed to be on a court appearance at 12 o'clock. The reason I think that's what I'm being called on.
I'm supposed to be at my barber at 11:30.
Okay.
I'm supposed to be at work at 2.
Let's go a few more minutes, unless somebody's in physical discomfort. Mr. Steggy, please proceed.
Mr. HANTTE, have you ever been under the care of a psychiatrist or a psychologist?
That's protected under HIPAA. Objection.
What's the objection, Mr. Pitaro?
I want to say HIPAA violation too. It's not relevant to any issue that we have here.
Mental.
I beg to differ.
Hold on. Mental health of an accused is a factor courts may look at in setting reasonable bail or other restrictions and conditions of their pretrial release. Now, the question is that particular question allowed without violating state or federal law? Mr. Pitaro, it seems to you that it might. Obviously, your client believes it does. Mr. Segi, can you give the court some authority as why that type of question will be allowed in this context?
Yes, in this context, it's an allegation I've made. It's also goes to HIPAA, right? Protects people who collect health information. HIPAA is not a nuclear weapon to be used against any question related to health. If there is concern about, I'm not asking about, so the legal, I couldn't ask about communications with any doctor. Sort of the privilege laws would apply, but we could read, and I have many times read HIPAA, and because it does not cover lawyers, does not cover court proceedings. The appropriate remedy is to seal the portion of his answer related to that question if the court is concerned about embarrassment, etc.
If we're done here, I'll.
Mr. Pitaro, I want to make sure I have your complete attention here.
Thank you, Your Honor. I'm just trying to get my 12 o'clock court appearance taken care of, and I think we've done that.
Okay. Well, here's the issue though, Mr. Steggy. This court has already allowed a request to have not only a video transmission of this hearing, but it'll be recorded and sort of likely published. So even if I were to say that this would be sealed, it would be out there and probably that's hard to claw back.
Right, but that's not a violation of the law or a rule of evidence, right? That question. And so perhaps embarrassing, perhaps, but again, not a violation of the law, and nothing would prohibit that information being before the court. I will make this offer of proof. Mr. Pitaro is in possession of a deposition of Mr. HANTTE where he does admit to the same.
All right, well, I will not require the witness to answer that question under oath in the context of this hearing, but for purposes of the offer of proof, I may consider that and how it bears on the relief being requested. Please proceed.
Thank you. Sir, were you also making insinuations when you went to the office of Tyson League?
No,
What was your purpose?
I merely asked if Mr. League worked there, as I stated previously. So you're trying to twist my words, Mr. Steggy, and I have already addressed that.
Mr. HANTTE, this is not your time to editorialize. These are yes or
I'm
no.
answering the question to the best of my ability, Your Honor.
Well, so Mr. HANTTE, here's how it works. The question was a yes or no. And then if Mr. Pitaro wanted you to explain your answer, if I give an opportunity further, you can. But right now he just asked if you were trying to insinuate something when you went there. All right, the answer, Mr. Steggy, is no.
Sir, what was the purpose in going to Mr. League's office?
I just went to his office to see if he worked there. That's all. Merely fact-finding, gathering information. That's all. No insinuations, no threats, no nothing.
You had never met him. Is that correct?
Correct.
And to this day, you have not met him, correct?
Correct.
You are not in the need of his services as a lawyer, is that correct?
Correct.
And the sole reason you went there is because of his connection to this case.
As I stated previously, gathering fact-finding information, correct.
And as the judge said, you answered yes or no questions, sir. And you admit you went to the FBI office?
I do.
And you went to not the front of the building, but to the parking area, is that correct?
Outside parking area, correct, where the voice call box is.
And looking for a FBI agent involved in this case, correct?
Actually, for the special agent in charge, correct.
In relation to this case?
Correct. Well, in relation to asking a specific question, not relation to the case itself, but a specific question which I never got to ask.
And was that specific question related to this case?
In a roundabout way, correct.
Oh, you didn't have pre-existing, prior to this case, business with the FBI, did you?
No.
And since you were fired from Reno Sparks Indian Colony, you had no active investigations or role in any police investigations. Is that correct?
I object to that terminology, firing.
Your employment was separated? How does that?
I was terminated off probation illegally, but yes, terminated off probation.
Since you were terminated off Reno Sparks Indian Colony as a police chief, you have no role as a police officer in any active investigations, correct?
Correct.
And certainly none that would affect would involve the FBI, right?
I don't know why I was prohibited, but I went to ask a question, Mr. Stagey, and I was summarily dismissed, as I stated previously in my testimony.
You say you were summarily dismissed. They say they were going to trespass you from the area.
Well, they also came to my house too. Do you know that, sir?
It's
No.
not, it's
Well,
not, it's
why
not.
they come to your house?
What's that?
Why did they come to your house?
To harass and intimidate. As far as I'm concerned, 3 agents showed up at my house later that afternoon while I was at work and tried to harass and intimidate my wife.
Okay, what they say. Were you there?
No, sir, I wasn't. She relayed that information to me through a phone call at my first break at work, which, by the way, I work at SA Automotive now, not as a delivery driver for Amazon.
Well, didn't you tell have you told your supervising officer that? Your new job?
What?
That you no longer work as a delivery driver?
What's my new job?
Yep.
Yes.
Okay.
So, Mr. Stagey, let's wrap up the
Yes, very good.
examination of Mr. HANTTE, please.
As to the firearm, you own the list of firearms that you gave to Mr. Meredith shortly after the first bail hearing. Is it your
I
testimony?
actually gave firearms to my first intake officer, Carlos Mendoza.
Okay. And that list includes a Smith & Wesson 4003 model 40 cal, right?
Belonged to my father, correct?
And a Kimber 45
Correct.
and a Star Super 9mm semi-auto, correct?
Correct. Correct.
And is that your testimony today, the fullness of the firearms that you own?
Well, there are 2 guns, long guns that are missing that my wife took and taken from the house, one of which I owned before our marriage and took them to North Carolina. So 3 pistols, semi-automatics that you just listed, Mr. Stagey, are within the possession of Mr. Harry Swift, have been there since I gave them to him. The other 2 guns, I have no idea what the whereabouts are of them.
But they were at the house before your wife took them, correct?
What? Which were? The guns?
The long guns that you just said your
Long
wife
guns
took.
were in Hawthorne, Nevada.
Has your supervising officer ever been out to your house?
No,
Has anyone ever been to your house to check on whether you are compliant with the no firearms?
no, and no one's even
laws?
checked with Mr. Swift to see if he's even have those firearms, which is kind of interesting in and of itself.
Have you ever met in person with your supervising officer?
I have not.
Your meetings consist of how many phone calls and electronic check-ins a month?
1 electronic check-in per week and Zoom hearings once every other week. And I've been compliant with those ever since day 1.
Okay, and so how long are the Zoom hearings or meetings?
Very 5 to 15 minutes usually, sometimes longer.
Last point on the social media, what were you well, you made statements about witnesses in the case. Is that true, right?
I'd have to look at the social media posts for specifics unless you want to give them to me.
You call Robin Renwick a murderer. Isn't that true?
Yeah, I believe there is a part of my analogy. It could be possibly true. Yes, and I've also put in there that I may have been a little bit overboard on that, and that would be in my subsequent post meeting, which again, private account. I don't know how you got that information, Mr. Stagey.
Okay. Final point. Isn't it true you recently made a post calling publishing something under your manifesto?
Yes, I'm in fear of my life.
Okay. And you analogized your what's going to happen in this case is the same thing that's going to happen to your dog that recently died. Isn't that true?
I don't see the relevance of bringing my dog into this. I object to that insinuation. That is a very personal situation. And again, private account, I do not know how you've obtained that information.
Mr.
and that's
HANTE,
illegal.
Mr.
Yes.
HANTE, it's just a yes or no question.
Yeah, the question is, did you say?
I
that-
did.
Okay, the same
I
thing is
did.
going to happen. Okay,
He said he did.
Well,
He-
thank you.
my dog passed away. Yes.
I have no further questions, Your Honor.
All right, you may summarize your argument based on anything you'd like to respond to Mr. Pitaro, any of the testimony from Mr. HANTE, and then I'm gonna let Mr. Pitaro ask a few more questions of Mr. HANTE if he thinks he needs to. In fact, let's do that before I hear the final words from Mr. Steggy. Mr. Pitaro, any last questions from Mr. HANTE? I think I know where you and he are coming from.
I just wanted to clear up so the court has the full picture. At the FBI office, you were talking over a telephone?
I was initially, Mr. Pitaro was talking to a voice box, then 3 agents came out and they were behind a wrought iron fence. They never passed through that fence. I specifically spoke to or Special Agent Chris Taylor. I didn't even get to finish the question about who I would talk to about a DOJ complaint when he summarily dismissed me. And I left. I got in my car and left.
And so the reason you're out there is that you wanted information on how you as a citizen could file a complaint against certain members of law enforcement.
Yes, sir. It'd be a RICO complaint through DOJ, correct?
And you were summarily dismissed and not allowed to ask that question.
Yes, correct.
And what did you do after that?
I got into my vehicle, went home, got ready for work and left for work. And I was there prior to 2 o'clock that afternoon.
Right. Thank you, Mr. Pitaro.
That's it, Your Honor.
Mr. Steggy, final thoughts, since it's your motion, your burden. You've heard the opposition. You've heard now testimony from Mr. HANTE, upon whom you'd like the court to change conditions of his pretrial release. Please summarize it promptly.
Yeah, yes, Your Honor. Clear and convincing evidence is the standard. That's what's been borne out today. A number of exhibits, all reliable pieces of evidence in the case against Mr. HANTE. I think there's a confusion by Mr. Pitaro or a tactic in either event. I'm not arguing that he shouldn't be able to go to the county commission. I'm not arguing about what his political beliefs are. It is a useful and tactic to sort of wrap himself in, oh, it's just political beliefs, or oh, it's free speech. I don't care about this. Does not even touch upon Mr. HANTE's free speech. And you'll notice I did not allege that the speech at a public hearing is a violation of bail, right? The First Amendment is robust, and I would never go near such a thing. I do not, but what it does illustrate is the defendant's mental status, his condition, and other things in the case. Similarly with the political views, ascribing what Mr. HANTE is saying both in his social media post as an opinion on politics, incorrect. I don't care about, no one cares about what his political beliefs are, although I disagree that a large minority of people have any such beliefs that Mr. Pitaro is trying to frame these as. This is very specific. He's talking specifically about the case, evincing a threat to people involved in this case, and a threat to the community, as well as sort of a conspiratorial thinking and the sort of the threatening conduct. I will get to now. Similarly, the wrapping in political ideology and wrapping in the guise of me trying to attack speech. He tries to attack my argument on mental health grounds, like, oh, these poor I'm not after mental health people. I'm not demeaning mental health issues. I'm asking that the court independently have Mr. HANTE assessed, given what we are seeing here as an alternative to simply revoking his bail and putting him in jail. Mr. Pitaro draws on his long experience of we all know how to do competency evals. Yeah, everyone here does. Totally separate standard. The standard for being competent, very low, very low. No one's alleging that he's incompetent. The question is what we're seeing in his behavior and as reflected in some of his speech, a danger to the community and the witnesses involved in this case? The answer is yes. Let's get to the behavior. Much was made about calling it nothing happened. Well, for nothing happening, the FBI, law enforcement officers themselves called the police on nothing. It is alleged as nothing. The reason that they called, right? The reason it's clear, I mean, it's an easy inference to make. Guy in a case who's a fired law enforcement officer shows up at your office only about the case, wearing a mask of intimidation, saying, hey, can't we handle this face to face? Yeah, that's why they called. Tyson League, a guy who signed the complaint in this case, has Stu HANTTE, a guy who he's never met, and HANTTE hasn't ever met either, shows up to his office and not, hey, is this where Tyson League works? What the reports say is he said, tell him Stu HANTTE dropped by, right? He didn't even know who that was until he went and looked it up. That is intimidation. Now, it is argued by Mr. Pitaro that he made no overt threats. Well, as irrational, and I'll point out here, Mr. Pitaro admits that his client is acting irrationally. But as irrational as his client is being, right? Not listening to his advice, doing stupid things like this, it's not that irrational, it's not that stupid. He's not going and saying, hey, making overt threats. It's all, as he says, insinuations paired up with the social media stuff and everything else. The wife. Now there's many pains are taken here to, and rather this is a throwback argument. Oh, the spurned wife, disbelieve her. That's a throwback argument. We don't believe that anymore. Same thing. The father-in-law called police, right? This isn't something, no one's like trying to burn him. They're legitimately concerned. She says he has a 9. Why is that incredible?
Hearsay.
Well, thank you, Mr. HANTTE, and as Mr. Pitaro called it hearsay too, right? Well, as we know, Title IV hearsay is admissible in bail hearings, right? He wants the spurned wife argument. I don't think carries much weight, because if she were going to burn him off or try to harm him, it would be a lot worse. It would be a lot worse, right? She would say he's got 10, right? Knowing, as we know now, no one is checking these conditions. That's the underlying problem. The court can order 100 conditions. No one's going to check them. We have no enforcement, right? We can say, you can't leave your house, right? You can only be at your house and nowhere else. Without GPS, that's on his word. No one will check. No one's been to his house. No one can go out to his house. No law enforcement certified personnel are employed by the court arm of supervision. As a result, my motion is well-founded. It's a clear pattern of intimidation, clear risk to society and the witnesses involved in this case. I submit, as to the mental health portion, I don't care what I don't care to see any evaluation if the court were to order it. The point is, to the extent it affects Mr. HANTTE and his impact on the public safety, it ought to be ordered. Not mentioned here, but of course, I think Mr. Pitaro would concede that no contact with any of the witnesses should be immediately ordered. But again, no enforcement mechanism available. GPS, that's the best way to do it. Second to that, remand into custody. And I thank you, Your Honor.
All right, thank you. The matter submitted, before we drop off the call, two things. One, I want to set a hearing on Ferretta. It'll be remote. It'll be next week. Like everyone to please check their calendars and tell me if the following date and time would be available. Thursday, the 20th at 9 a.m. So a week from today at 9 a.m., not 10 a.m., 9 a.m. Mr. Pitaro.
No, Your Honor, that is the one day I can't, my son is going to be going in to have surgery that day, and I'll be with him. The other things, I mean, I can get other attorneys to take care of them or continue them, but that is the one day I am not going to.
Well, I would like you here. So let me ask you this. I can do 1:30 on Wednesday, the 19th, 1:30 Wednesday, the 19th.
No, Your Honor.
That
I
doesn't-
have to work. I have to work at 2 o'clock every day, Monday through Friday. I don't want to impact my work. Anytime in the morning is convenient for me. And I will be more than accommodating to the court, which again, I don't believe has authority here, but I will be more than accommodating to the court in the morning hours. I have to work in the afternoon. That would impact my work. And then I just started back at my old job, which of course has not been mentioned. And that's where I work 2 p.m. to 10 p.m., sir.
$11 o'clock Wednesday, the 19th. Ferretta hearings, we'll be done by 12. That accommodates Mr. Pitaro's unavailability Thursday, Mr. HANTTE, your work schedule, and let's start with Mr. Pitaro. Would 11 a.m. Wednesday, the 19th work?
Your Honor, I don't know what appearances are, but I've got other attorneys that I will have them do it, and I'm sure if there's no judge is going to get upset if say that I'm on a hearing up on Zoom in Reno when I have to be on it. They'd be as accommodating as anyone else. But
Okay.
I don't see that as a problem.
All right, Wednesday, the 19th, 11 a.m. Mr. Steggy, the district attorney's office work. All right.
Yes, thank you.
All right, thank you. So Mr. HANTTE, make a mental note, please, Wednesday, the 19th, 11 a.m. This matter is now set for a hearing on Zoom under the Ferretta case. Let's move on. I want to just check a couple emails I was asked to look at before we end this hearing. Give me just a moment, please.
And Your Honor, may I speak after you've checked those emails?
Just a moment.
Thank you.
Ms. DeGaynor, was it just the one email you asked the court to look at? Mr. Gaynor, you're on mute.
Yes, Your Honor, I believe there should have been 2 regarding the same topic. Let me make sure the other one went through.
Okay, I've read the email. Thank you.
Thank you.
The one I got. All right.
Your Honor, I don't know what this email is that you're referring to, so
It's just between my court clerk and I regarding somebody in attendance
okay, I see.
for the hearing.
All
they're
right, that's
not
nothing
a-
to do with us.
They're not an attorney in this case, or they're not a party, and so I'm not prepared to respond to the email right now on the record. All right. Somebody said they wanted to say something. Mr. HANTTE, if that was you, I'm reluctant to give you a form right now for multiple reasons, because I want to put you in the best position going forward in this case. And I want to make sure that you don't say anything now that could work to your disadvantage. Mr. Pitaro is still your attorney until I release him of his obligation to do so. If the end of the Ferretta hearing, you determine you want to represent yourself, and if you want to terminate his services, I would suggest to use this opportunity over the next week to decide if sincerely that's what you want to do. But if there's a quick question other than something like that, go ahead.
I'll defer to Mr. Pitaro since he's still representing me, and I'll withdraw my request to address the court.
Good thinking. All right, thank you, Mr. HANTTE. Mr. Pitaro, thank you, Mr. Steggy. The matter's under submission. I don't know if I'll have a written order out by tomorrow, I'll shoot for that. If not, it's unfortunately going to have to wait until Tuesday. I know this is an important issue to all sides, but the court will give it its immediate attention. Thank you, everyone, for the excellent presentation. I wish you a nice afternoon. Stay well. With that, the court will be in recess.
Thank you.